Good afternoon. Did you see the two pieces of legislation I sent?
Yes, ma'am.
Okay, all right. That's our topic for the day. When we talk about compliance, company compliance. Let's see who else is coming on. For today's class. Shirella will give them what? 10 minutes or 5 minutes? Because it's 12:05.
I think we give them another 5 minutes.
Okay, all right.
Okay.
Then we'll get started because it'll be recorded anyhow.
Yes, ma'am.
Yeah, okay, let's give them 5 minutes then. That's 12:10.
Okay.
Okay. Okay, Sharella, let's start.
Yes, ma'am.
All right. So chapter 9 speaks about company compliance. And company compliance can be directed in two ways. One, it speaks about a CAC or an IBC and what they're required to do in terms of their regulatory or statutory reporting to the Registrar General. But also, you can look at company compliance in terms of an FCSP. And an FCSP has certain obligations under the Act that it must carry out in order to be in compliance to provide the service that the client has contracted with them. So you're looking at it from two different aspects. So in the chapter, it says that we know that IBCs are normally very vulnerable for money laundering, terrorist financing. I mean, for any type of identified risk that has to do with moving illegal money to making it legal. So we know that's just a part of one of the attractions to the IBC product. Hi, Christina.
Hi, good afternoon, everybody.
Good afternoon. We just started. So as an FCSP, you will see when we go through the legislation, which is the newest enacted FCSP, you will see what is required. And what the Securities Commission has done is that they have beefed up the requirements where there's a lot of obligation and duties on an FCSP in carrying out this function. And your notes also speak to the corporate services may assist the launderer by allowing them to divest themselves of legal ownership. And remember, in some corporate service providers, services, they offer nominee services. So which means that the ultimate beneficial owner name is not on the annual returns. And so that's another feature where the international market says it makes it more vulnerable because you don't really know who you're dealing with, even though the corporate service provider has to know who is the ultimate beneficial owner and obtain due diligence on that person. So let's start off by looking at the act itself, the Financial Corporate Service Providers Act. Christina, you saw the email, right?
Yes, I saw the email. I have it open up.
Okay, all right. So now let's turn to the act. And let's go through the sections that are important. Hold on, I'm going to the first page. All right. So the first thing you have to realize is that in order to provide corporate services in the Bahamas, you have to be licensed. Licensed via the Securities Commission. So Section 4 speaks to the requirements for a license, and that you have to put in an application, and that application is to be reviewed by the Securities Commission. So go to Section 4. And it says, subject to Section 6 and 7, and notwithstanding any other law of practice, no person can offer financial service and corporate service, or be engaged in that business, or act as one, whether you're operating in the Bahamas or from within the Bahamas. you have to obtain a license. And then it says in order to obtain a license, you cannot be a person who fits into section 5, which is the disqualifier. Because it says if you are an undischarged bankrupt, if you are prohibited from being a director, and when they say prohibited from being a director, in many financial services sectors, they have a law where there is a listing at the regulatory bodies of persons who they have placed prohibition orders on. So say if the regulator goes in, does an examination, or the regulator gets information from within the institution, or the regulator does his own on-site examination, or the regulator is informed from another regulator that they are placing a prohibition order on a director, either because of his actions, or maybe they found out his qualifications were not valid, they can put a prohibition order on that person, meaning that that person can either no longer be a director in any financial institution, or that person cannot work in that capacity for the next 5 years, 10 years. So that's what they mean by when they talk about if there's been any prohibition from being a director. If you've been convicted or is convicted, you're disqualified. Is a person whose license or registration has been revoked. So if you were part of an entity that was revoked by the regulator, then you will not be able to get a license. And being a legal entity, and your controlling owner, director, or senior manager was disqualified under any one of the preceding sections, A through D. Any comments there? No? So, like all applications going to a regulator, you can't just send in an application form. You have to send in your policies and your procedures, in particular for money laundering and anti-terrorism. Because remember, providing that corporate service, it makes the products that you're going to offer to your clients very vulnerable to those two risks. Of course, you must have a business plan, and depends on your business plan, they'll ask you, the regulator may ask you other questions to see how feasible your plan is. The law requires under Section 8 that you renew your license annually on or before the 31st of January every year, and of course, pay the applicable fees. And of course, the commission has the authority to automatically revoke your license where you fail to renew it prior to the annual renewal date, or if you don't comply with the requirements such as the annual update form and the declaration form. And where applicable, you also have to submit a current copy of the insurance policy for your FCSP. And of course, you know that you can go to the commission to have a replacement license if you can't find it. If you decide that you no longer want to do business, you can surrender your license. You can always withdraw your application. You could apply for your existing license to be varied. You could add other services to it. Now, the commission has an obligation because the license is FCSP. It's required by law under Section 13 to keep a register. And in that register, it has the name and address of every FCSP that has been licensed, the name of the CEO or the managing director, the name of the compliance officer and the MLRO, and of course, the type of services, because you are billed based on the type of services you provide. and then the date in which the license was either issued or varied, suspended, or revoked. And under section 15, always be mindful that your license has to be displayed. And so it has to be in a visible spot, and normally it's in the front when you walk in, because it has to be someplace where the public can see it. It can't be hidden. So under part 3 of the FCSP, it speaks about the conduct of business. And under the conduct of business is really talking about what are the duties of an FCSP. And the general duty is to comply and cooperate. So they said that any licensee under this act, as a part of their doing business, they must deal openly, honestly, and cooperatively with the commission. And they have to provide to the commission any information that they ask for, as long as it's relevant to your business. So when they would send out these surveys and these questionnaires, they normally would give you a time frame. But even if there is no time frame on it, it is not something when you have a request from a regulator that you sit back and let it wait for a week or 2 weeks. You normally try to answer it right away. If it's not relevant, then you would send an email back and say, not applicable to our business. So they could tick the name of your company off the list. And then of course it says you have a general duty to cooperate when there is an on-site examination or off-site examination. An off-site examination means a desk examination, where you just answer questions from a survey. Any questions so far? Christina, Shirella?
No, ma'am, no questions.
No questions.
Okay. So you see how onerous it is in carrying out this business now compared to when it first started. It's not just a shuffling of a piece of paper. You have serious duties and obligations to carry out as an FCSP. So it says any licensee, the employees, the managers, the officers, or any person connected to it who fails to cooperate with or who obstructs or assaults anyone who acts on behalf of the commission commits an offense. And then of course, section 17 speaks to the duty to maintain professional conduct. So they say in addition to complying with any prescribed requirements, because remember now the regulator, when it grants you a license, can give you additional requirements. They say each licensee should act honestly and fairly with due skill, care, and diligence, observe and maintain a high standard of professional conduct, and of course, refrain from engaging in any improper or illegal conduct. And you'll see later down in the regulations, it speaks to always having persons within your employ who have the requisite experience and knowledge to carry out this function. Then the act goes more into what they call the continuing obligation of an SVSP, and one of them mainly being the duty to notify if there's any changes to the regulator. And then the duty to obtain approval for certain changes. So it depends on the nature of your business. If you want to expand your business or you want to decrease your business, you still have to advise the regulator. There's a duty to maintain adequate financial resources and solvency. And that means that you have to be able to demonstrate that you have the adequate financial resources for the nature and the scope of the services that you're providing. And you have to also look at the risk that are inherent in your business. Section 21 speaks to indemnity insurance, and where you have not been specifically exempted, every licensee has to secure and maintain adequate insurance and make sure it's appropriate based on the activities and scale and the complexity of their business. And on an annual basis, they have to review the amount and the type of insurance and make sure that they have sufficient coverage. Of course, the commission can require annual audits. Section 23 speaks to prevention of money laundering, being in compliance with the Financial Transaction Reporting Act and the Financial Intelligence Unit Act, regulations, and the Anti-Terrorism Act. And that's broken down a little bit more under the FCSP regulations. The next section of the Act just speaks to the power of the commission, what the commission can do, such as paying fees, have an inspection. They have the right to enter into your premises. They have the power to investigate. And of course, they can issue fines for offenses. And they have the right to ask you for information. And of course, being the regulator, they also can suspend an FCSP's license. They can revoke it. And they have a process for that. And of course, like under any regulatory regime, you can actually surrender your license. And of course, the Act speaks to sharing information. Any comments on the Act itself?
No.
Simple and straightforward, right? Yes, no?
Yeah, it's straightforward.
Okay, so now let's go to the regulations. Why did mine disappear? Oh, it didn't. It's me. I have mine on a small screen. Okay, so the Act spoke to preparing your annual updates and your declaration form. And the regulators are stickler for those things being on time. Otherwise, of course, you're fined. So Section 3 in the regulation says that a licensee shall, which means that you must submit your annual update and declaration form in the format set out in the 5th schedule. So when it comes to if your business is an FCSP, then you know that as an FCSP itself, you're not talking about the clients underneath you now, that you're offering the RO services and the RA services. This is just the FCSP. You have obligations to the Securities Commission. And then when it comes to your clients, then again, you have your statutory requirements to the Registrar General. So you normally have like 3 to 4 different checklists that you have to maintain to make sure that you're always in compliance and you're not fined. So for the FCSP, the first thing is your annual updates and declaration form has to be completed and sent in. And of course, you have to pay your annual fees. So that's 3 and 4. So part 3 now speaks to the general duties and obligations of FCSPs. And the first thing it says in Section 5 is that you have a duty to make, keep, and maintain records. And those records are relevant to your business. So here they're talking about the FCSP's file and making sure that in addition to the file for the FCSP, you also have to keep and maintain records for all of your clients. Notice that the act, like other pieces of legislation in the Bahamas, doesn't tell you how to store it. You have to just store it whereby it is retrievable. And of course, the statutory period for retention of records depends on the type of records that they are. Then accounts have to be kept. A licensee has to keep and maintain for a period of not less than 6 years proper recording of his business transaction and financial affairs, and any other document that the commission may state that they need to keep. And of course, it says that an FCSP, where required by the commission, and when you see that phrase, where required by the commission, it means that not all licensees have to do the requirement under subsection 2 of section 6. It says within 120 days following the year end, submit annual financial statements and a copy of the annual report of the auditor on the results of the audit. And then within 30 days following the end of each quarter, submit interim financial statements. Now, that part of it in subsection 2, the commission is working on that now to have an automated portal for as licensees to upload this financial information. So they're working on that, trying to have that finished by the end of this year. And it says here, once that is up and running, the penalty for anyone who failed to upload their financial information, the penalty is $1,000 a day. So section 7 says, in addition to any other records, the commission may require to be kept and maintained. A licensee should also keep and maintain or cause to be kept and maintained records on the shareholders and the owners, legal and beneficial, with respect to their clients and with respect to their own business. So whenever you're doing your part of your due diligence, you see that the law requires you to obtain information on the shareholders and the owners, legal and beneficial. And the same thing is for their own business, which means for the FCSP itself, you have to know who are the owners. It says an FCSP also have to have internal controls to ensure compliance with the act. So that means that on the FCSP side, they must have policies and procedures dealing with the services that they provide. And I was telling you in the act about your duties, and under section 8, subsection 2, it tells you that the staff and the management of those staff, they have to extend ensuring that staff are appropriately qualified and experienced for the level of their responsibility. So there's no excuse when an examiner come in to say, I have not been trained, because the law requires that staff are appropriately qualified and experienced for the level of their responsibility, and the FCSP has to provide training courses to assist the staff in understanding and complying with the company's policies and procedures. So all around, there's training. Now for client relations, the regulations speak to the agreements and any notification or information that you provide to your client in terms of your service and your fees. It has to be fairly and clearly presented, and it should set out in adequate detail the basis on which the licensee services are provided. And it says that the language itself in the service agreement should speak about the scope of the duties to be undertaken by the FCSP, a statement that the FCSP is a regulated person and that they follow the law, a statement that the information may be disclosed if required by law, the governing law and jurisdiction, which would be the Bahamas, and then of course the fees. You can add in that also any instructions in terms of wiring instructions, and also to let the client know that if they have any material changes, it should be advised, or vice versa. And of course, the regulations speak to the FCSP in terms of trying not to exclude their duties and liabilities onto a client. Now, section 10 of the regulation says, where the commission requires a licensee to provide at whatever time they ask for the following information. And that information is the natural person, the client record showing total number of clients, their nationalities, place of residency, total number and types of transactions undertaken during the period on behalf of such clients. For legal entities, whether it's corporate or incorporate, client records showing place of incorporation or formation, total number and types of transaction. And again, section 11 speaks to having an auditor if it is required by the Securities Commission. Like in the Act, it speaks to the FCSP having a duty to permit examination and to produce documents when requested by the Commission. Section 13 speaks to the duty to implement data protection measures. It says the licensee shall implement and maintain data protection measures consistent with the provisions of Part 2 of the Data Provision of Personal Information Act concerning the protection of its clients' personal data. And the licensee shall ensure that its data protection means provide protocols for the collection and storage of personal data, implementation of appropriate security measures to prevent unauthorized access to or alteration, disclosure, or destruction of personal data, and of course, rectification. And linked to this section 13 in the regulation is the offenses and the penalties under the Computer Miss Act. Section 14 speaks to the duty of confidentiality, and it says, except where disclosure is required by operation of law, no licensee shall disclose to any third party any information related to its clients or the client's relationship with the licensee without the client's express consent. And that's a little bit different, or it's a little bit narrower to section 77 in the Banks and Trust Companies Regulations Act, which speaks to preservation of confidentiality. Section 15 speaks to conflicts of interest, and that a licensee shall avoid any conflict of interest, and where it arise, they need to disclose such conflicts consistent with their duty of confidentiality, or just decline to act. And then the regulation gives out the consideration that the commission would use to determine if someone is actually fit and proper. Section 17 speaks to due diligence measures, and the due diligence measures goes hand in hand with section 23 of the Act, which speaks to one of the duties of an FCSP to prevent money laundering and terrorism. And it says here that the FCSP has to implement due diligence measures on an ongoing and continuous basis. They have to apply it when a business relationship is established, and if it is suspected that there is money laundering or the financing of terrorism. They have the verified identity of each client and each client's agent, and it gives you a breakdown. If it's an individual, the date of birth, the ID card, the birth certificate number or passport number. Is a body corporate, the date of the incorporation. Get the telephone numbers, the electronic mailing address. It's a partnership, identify the directors, the shareholders or partners. And where there's no natural person ultimately owning all the assets or undertaking of a body corporate or partnership, they should identify the natural persons who have ultimate control or effective control or executive authority. Section 18 speaks to the compliance function. And it also permits an FCSP to outsource that compliance function. Section 18 speaks to the appointment of an MLRO, and that person should have sufficient level of authority and independence to perform the role without interference by any other person. They report directly to the board or committee or to senior management, and they should have a sound understanding of money laundering and how anti-terrorism and countering the financing of terrorism framework applies to the FCSP's business. They should also have the relevant academic and professional qualifications, and of course, have practical experience. And as stated in the Act, the FCSP should have internal policies, procedures, and control. Okay, and then the end of the regulation gives you examples of the application forms. Any questions or comments? Yes, no?
Yeah,
For me.
I have a question.
Go ahead.
If you wanted to apply as just an agent, that's done through the FCSP as well, right?
What do you mean agent? Agent to do what? Accounting?
No, an agent to do not corporate, I guess corporate, like in corporations and stuff like that.
You need a license.
As an agent or as a full FC?
FCSP, that's an FCSP.
Okay.
See, and now as an FCSP, when you go into the section, you'll see the services are broken down. When you apply for a license, it's not like an all general license. You have to tell them what it is, what services you want to provide. So when you say incorporate, you mean just incorporate a company by itself? You're not offering registered office or registered agent services?
Right, yeah.
So when you incorporate the company, then you're doing that as a lawyer.
Oh. So that's not necessarily, doesn't necessarily require licensing through the FCSP?
When you're gonna no, but that's what I'm saying. When you say you're incorporating through an FCSP, that FCSP has to have a license.
Right, to offer like the registered office services and stuff like that. But you don't have to if you're doing so as a lawyer. That's why I want to clarify.
I know where we are, all of our incorporations are done through our corporate service.
Okay.
And that's why you see a lot of law firms have corporate service.
Okay.
Yeah. So the corporate, the lawyers would meet with the client. The client, whatever transaction the client is doing, the client will say whether they're doing it in their name or they want to incorporate a company to carry out the transaction. Once they say that they want a company, then that information is then sent to the corporate arm who would incorporate the company.
Thank you.
Yeah, so that's the process. No more questions? Because being an FCSP now is not a simple job as just taking on these people's money and listing the companies. There are obligations as an FCSP under the act and under the regulation. And it can become quite onerous. And that's why you see the requirement that you must have skilled employees with experience, because then it is dependent on the persons that are doing the work to be able to meet all of the statutory requirements under the CAC or under the IBC Act for the clients. If you're having 100, 200, 300 of these clients, you can see the amount of work that's involved. Okay, so now let's look at a CAC. What's required for them to file annually with the registrar? You know, by law, under section 17, they must have a registered office. Agreed?
Agreed.
Okay, so that's the first thing. So what other requirements are they supposed to have? Whether that CAC is a standalone entity or that CAC is under an FCSP. What is required by law? What filings do they have to do? So one is, they must have a registered office. What else? Under section 18,
They should, the corporate documentation, they must filed with the registered office must also be a copy of the memo and arts.
yes. What else? That's section 18, A. Copy
And
of the
then-
memo and articles and all the amendments. Always remember, and all the amendments.
Amendments, okay.
Uh-huh.
And then any meetings that they had, shareholders resolution, that should be included as well.
Mm-hmm.
List of directors, shareholders, and officers.
What section is that? You're going too fast though. When they say maintain records at your registered office, remember now, section 17 said you must have a registered office as a CAC. And you have to maintain records at that office. And those records include the memo and arts and any amendments, the minutes of the meeting and resolution, any notices that were required under the act. So you must have a file for that also. And any register of such document or like document that is required under the act. So that's the company records. So that same subsection D, any register or such like document now goes to what you were saying, the register of directors. So where is it required in the act for you to have this register of directors? Where are the volunteers? I heard someone say register of directors.
Section 44 of the IBC of the
No, we don't CAC now.
CAC. Register of directors.
I'm looking because I can't remember the section, so give me a minute.
Yeah, no problem.
section 56 of the CAC.
56 says, read
the
56.
Register of members. Hold on.
So
subject
is
to
that
the-
directors?
Wait, hold on.
I'll go with 59 then.
Shirella, you guessing this or you
No,
confident?
because no, section 59 says a return on the subsection shall be signed by 2 directors. It doesn't spell out register, but I don't see anything that explicitly states that.
I saw it though. I'm trying to find where I saw it. I saw it though.
Oh no. Oh, sorry.
And I don't want to say it ain't 58 because that's like annual list of members and return. That's like, that's not the same thing.
Okay, so 56 is the register of members. 58 is the annual list of members and return of capital, shares, call, etc. And then 59 is the beneficial ownership. So this section 58, what's on this annual list of members, return and call, etc.?
A company incorporated under the act shall cause to be kept in writing at its registered office on one or more sheets, whether bound, names and addresses and occupations, if any of the members of the company, with the addition, in the case of the company having a capital dividend into shares, of a statement of the shares held. I guess it is this then, 56. Because it's name, addresses, and occupations of all of the members. That's like shareholders. Let me see, data registered member.
Yeah, but it's only speaking about shareholders.
It is.
Mm-hmm. Says member.
Okay, I saw it, but I can't find it. I'm gonna keep looking. Shareholders.
And you know, you have to file under section 59, the returns in respect of beneficial ownership. But we all see when you're looking at a company, we all see a register of members and we also see a register of directors, correct?
Yeah.
Correct.
Mm-hmm. So now my question is, where's the requirement for a register of directors?
Okay, section 89.
Let me go there. 89, filling a
Wait, hold on, hold on,
vacancy.
wait.
That can't be right.
Wait.
When y'all give up, I'll tell you.
No, not yet.
No, I'm not telling you yet.
Disqualified.
Giving you time to look it up. And make sure you're circling these, because when you're doing the practical side of this and you're finishing the course, you'll know where to find it. You may not have to memorize it, but you'll know, okay, when we went in class, we're looking at a CAC, what are the statutory filing requirements? And then you could read the act just to make sure that what you're producing is what's required by law. Let me know when you give up.
I already gave up because I thought it was 56.
Okay. Christina, you give up?
For the sake of time.
No, don't try it. Don't try it. Did you look? Did you look?
I'm
That's
still
the-
looking. I'm literally still looking. I thought it was around that same section. I don't remember it being beyond 90.
Okay. So go to section 80, subsection 4. You see why I told you all to start to read this if you're dealing with CAC companies or both? What does it say? Every company shall keep at its registered office a register of directors and managers containing their names, addresses, and occupation, and shall send a list of such names, addresses, and occupation to the registrar and any amendments thereto. You see it now?
You said 80 subsection 4?
Yeah, huh?
Why my 80 don't have a subsection? What I reading?
I don't know. You under the CAC?
Yeah, oh, the front page says an act to consolidate and revise the law respecting incorporation management and control of companies,
Mm-hmm.
as amended by Act number 24 in 1993, blah, blah, blah.
So what your section 80 says?
My section 80 is special requirement regarding notice of meeting.
Hold on then. You're numbering off.
Yeah.
Look for go under part 2 in your index. Not part 2. Go under part 4
Okay.
where it says the directors.
Okay.
Okay, and the first section is the duty to manage the company. And the next one says number of directors and remuneration thereof.
Right. So mine.
That same one.
Yeah. Right. See, it's here. I see it now.
Right, that's it right there.
Yeah.
Yours may just be the numbering because they've been doing a lot of amendments.
Yeah. So mine's is 85 subsection 4.
Okay. So, because a lot of times you don't really need to know the section number itself, unless you have the most recent consolidated version. But if you know that under part 4, which deals with directors, and then you could say the subsection speaks to the requirements of a CAC having a register of directors, you can find it. Because once you go to part 4, if your numbering is different, you should still be able to find it. So right here, you see what it says. It says you must have the name, the address, and the occupation, and that has to be sent into the registrar. And any amendments there too. So whenever you make amendments, you have to reflect it on the register. Now, is there any other?
I have a question.
Go ahead.
I have heard like a lawyer say before, but I don't know how accurate this is. That, well, no, it wasn't a lawyer. A colleague said that you can't make too frequent of changes for the list of directors within a year. How true is that?
Why not?
Like, that's what I was wondering, because I
That doesn't
feel.
make any sense.
Say again?
Doesn't make any sense. Let's just say we were running a company.
Right.
And we had 6 directors. The only way I could see that comment being made is if that company is it could be an indication that there is a problem in the company, people are leaving, or it could raise a red flag to a regulator.
Oh,
But
okay.
companies, because some companies twice a year change directors. The
And
person may
file it.
decide to leave, the person died, the person gets sick. I don't like the
Right.
way in which you run it. No. Why?
And they file it, right? Like immediately after, within the 14-day period.
Uh-huh.
Okay, because I was trying to figure out how that even made any sense, because I was wondering if the way that it was said, it was that the particular director didn't want to be a part of the company anymore. And they had to wait until the following year, something like that, to file. So the director had to kind of stay in position until the following year. And I was like, what? That's crazy. I don't know.
But why would you have to do that? And it says any amendments can be made.
Yeah, I don't know.
Because the thing about it is when a director resigns, he would submit a letter. The person who is replacing accepts. And then the board resolution speaks to one, the resignation, and part B in that same resolution speaks to the appointment. And you amend your register at that point in time.
Okay, all right.
Now, you could at the beginning of the 14 days of the next year, when you send in your register of directors, all of those changes should be reflected. If, let's just say, in between that person leaving and before the end of the year filing, the 14 days after the year end, you have a request. It could be like, say, from a correspondent bank, and is asking you for a copy of your register of members and your register of directors for their records. So that means that it has to be stamped. Your register is already updated and you send it in to have it stamped. So I don't understand the comment saying, no, that don't make no sense. No. You amend those registers as changes are made. Any other filing requirements under the CAC? Anything else you have to submit?
Someone already say financial statement?
No, nobody said it.
So that.
What's the requirement?
Now I gotta find it.
Of course, you volunteer, you have to find it. If you say it, you have to find it. Come on, somebody else. What else? While she's looking for that, what else is required?
Okay. So, section 59 speaks to returns in respect of beneficial ownership of shares. So, in my thing, so it says every company incorporated under this act shall, before the 1st of January and each year after the year in which the company first commenced business, submit to the registrar a return declaring whether or not 60% of its shares are beneficially owned by Bahamians.
Mm-hmm. So, that's the beneficial ownership declaration.
Oh, that's not the same as what I said.
No, you say financial returns.
Oh, okay.
I'm waiting on that one. And while you're looking for that, someone else needs to say anything else after the financials. We're talking about what needs to be filed now. Don't confuse the requirements to be submitted at the AGM versus statutory filing to the registrar. Audited financials are not submitted to the registrar, but they have to submit it at the AGM.
We said the annual fee, right?
No. There's a required annually to pay a fee. But I thought y'all was posting about 6 weeks ago that, oh, I started to read the act. What happened?
Who could really remember? Who? That's impossible.
Oh, Lord.
Oh my gosh. Okay, so section. No, never mind.
What you mean, never mind? What happened?
No, because it was wrong. That was the wrong part. Oh dear.
This is literally like reading the Bible and knowing what in it, not knowing where it found. This is literally the same thing.
2nd John and not 1st John.
See, exactly.
But that's what I'm saying. This is not something you memorize. You just have to know where to go to find it. And that's why I said you needed to circle on your in your act, all of the ones that you'll always be coming back to. What that is you looking for again? I'm trying to remember what you're looking for.
I was just looking for financial return, but I think I really meant the first thing that I was reading.
Yeah, the financial return goes to the members. That's at the AGM. And then remember on an FCSP itself, the licensee, they're only required to submit that to the regulator if it is required. So nothing else.
I think I gave up on the financial return.
Okay. Now remember, once you've done all of your filings, there are certain vendors that would request a certificate of good standing.
You're right. And that's 284, by the way.
Oh, you know that one.
Yes, because I was looking for financial return.
And you saw certificate of good standing.
Yeah, I thought that's where it was.
No. Okay, certificate of good standing. And of course, there's penalties for false reports and false statements. And so that's why it's so important to keep accurate records. So if you were to act as a company secretary, you would have to know the filing requirements, the statutory filing requirements for the CAC, but you'll also have to know all of the requirements for the AGM.
I have a question,
Mhm.
or I don't know if it's a comment, but I noticed that the registered office states, or there's an option, not even the registered office, on this, there's an option to just adopt the first schedule. Is
Mhm.
that then all of this stuff here that speaks to like accounts, notices, and all that stuff, but inside the Companies Act, or is that something else?
What do you mean? I don't understand the last part. What do you mean?
Like for the memorandum,
Right.
if
If
you choose to adopt the first schedule, is that the information that's found in here? Because I noticed with like memorandum, it has a lot of these things like notices, accounts, management, like all of that stuff. So is it like saying that you adopt all of what is already in here?
no,
That's something else? The first schedule is found somewhere else?
the first schedule at the back is like a general article.
You mean,
Yeah, it's at the back. That's the back of the app. So it depends on how you want to run your business. You will tweak these articles.
right,
Wherever there's a section in here that is silent, you refer to the act. Or if there is a section in the schedule and it's not clear, you go to the act. Even if you wrote your own articles, if there is some controversy as to what exactly it means, you go to the act. So let's go to the schedule. Let's find a typical section. Let me find one that would not be too difficult. Find one. Okay, so general meetings. In the schedule, it says the statutory general meeting of the company shall be held within the period required by section 65 of the act. So it sends you back to section 65. So if you wanted your general meeting to be at a different time, when you draft your articles, you would make that change. And so section 65 is very long. It says a general meeting of every company incorporated under the act shall be held once, at least in every year. So all the schedule said was that you will follow section 65. So if you wanted to know how a general meeting is to be called and how it is to be conducted, it's telling you that it's following section 65. Then it says in the schedule, it should be held once every year at such time and place as may be prescribed by the company in general meetings, or on default at such time in the month following that in which the anniversary of the company's incorporation occurs. And then it tells you in default when it shall be. But in other jurisdictions, there is no long memo and arts. When they incorporate, it's just one sheet of paper. That's it, saying that they're incorporated. And what they do is they just tick the box to acknowledge that they will be adhering to the schedule. There's no long, these long documents. But for most CAC companies, you will see memorandum and articles of association. Any more questions on that?
no, that was good, thank you.
Okay, so now let's go to the IBC that you're also excited about.
Not excited, I promise you, I read nothing about the IBC yet.
What?
Saying, I'm here, open ears to learn though. That's like
All
the
right.
New Testament.
Okay, all right. That was the Old Testament just now. So this is the
Yeah.
New Testament. All right. So what's required of an IBC, which is much easier? What's the statutory filings?
The register of directors and officers,
Sections.
44.
Let me see if I have mine circled. Yes. That's it?
No, it's more, I just wanted to give other people a chance.
Okay.
Go
All
for
right.
it, girl. You got this.
What is this?
Go for it. Go off.
Certificate of good standing, section 190.
Okay, let me see if I have mine circled. You missed some, but go ahead. What else? No other filings?
Yeah, it's more. And then section 8 would be the fees, the annual fees.
Section
Sec-
what?
Section 8.
8?
Mm-hmm.
Let me go to my section 8. Oh, I'm too far up. You ain't get no help for today. Why you get section 8 say pay fees?
No, no,
Mm-mm.
my bad.
Section 8 speaks to limiting liability of members.
The text says section 8 of the International Business Companies Amendment Act 2014 outlines the fees
Oh.
to be paid.
That's
with
from the
respect-
amendment,
Oh,
not the
okay.
main act.
Okay.
That's that amendment. What else? Someone made a comment this week to me, said, I don't know why we just don't repeal the Companies Act and just keep IBCs. What are your thoughts?
Why? Is it
There's too much,
because
say CACs is just too much work,
an IBCs isn't?
not in terms of filing.
Oh. But aren't IBCs, don't IBCs have to be managed under someone that's registered with the Securities Commission?
Yeah, an FCSP, yes. You can also have your regular CACs also on an FCSP, you know.
Yeah, I know that,
Yeah.
but that's not like mandatory, you know? That's why I asked why.
They're talking about the filings. Because don't forget now, just like how we went through the CAC, that constant updating of registers and having meetings every quarter. IBCs don't have meetings every quarter. They may have one once every 2 or 3 years. Most of them are just a one-man man.
Right. And IBCs is also where they could kind of conceal the beneficial owner. So that's not
Yeah,
like a public registry situation.
Yeah, but even in the CAC, you could have nominee shareholders.
Yeah, yeah.
Okay, so you gave me the register of directors and officers. They have to be filed for an IBC and have to be available to the public. And you only need to file that once a year, so after 12 months. And the act also speaks to if the register is not filed, within the 12 months after the appointment of the directors, the Registrar General has the power to strike off that IBC. So any change in the directors and officers, you have 12 months to advise the Registrar General of that change. Any other filing? No? Or still looking? So even though there aren't a lot of documents to be filed with the registrar, remember an IBC is required by law to have a registered office. So what should be maintained at the registered office for an IBC? Let's start with section 29. It should have a share register. What else? What else should be at the registered office? The memo and arts? Anything else? And the register of directors and officers. Now the act also speaks to, and this is the difference between the CAC and the IBC. You see how quick it is for the registrar to strike off an IBC? If you don't file your register of directors and officers within 12 months, you can be struck off. Then go to section 165. 165 speaks to striking off. Hold on while I look for mine. It says where the registrar has reasonable cause to believe that a company incorporated under the act no longer satisfies the requirements for an IBC. And those requirements are section 14, subsection 1, which speaks to the articles. Section 38, subsection 1, which speaks to registered agent. And section 44, which speaks to register of directors and officers. The registrar shall serve on the company an order for compliance. And after being duly notified under section 2 of the Commercial Entities Substance Requirement Act, that a company is non-compliant, they can serve an order on that company for compliance. And if the registrar doesn't receive a reply within 90 days following the order, they shall strike the name of the company off the register. Unless the company or any other person satisfies the registrar that the name of the company should not be struck off. Now, if the company sends a document to say that they're in compliance, then of course, the registrar will send a declaration of compliance. Of course, if you fail to pay the license fees, you will be struck off. And a company that has been struck off the register under section 165 remains liable for all of its debts and claims and liabilities and obligations. And if the company has been struck off under section 165, subsection 2, then the company or creditor or member or liquidator can, within 5 years following the struck off, apply for the company to be restored. And so other than that, there's no other filing requirements. And of course, you can request a certificate of good standing under section 190 of the IBC Act. And of course, there are penalties if you don't have a share register or if you actually submit false reports. Any comments?
I have a question. I don't know.
Go ahead.
Okay, with companies incorporated under the CAC, do those companies share the right to be able to own shares in other companies, or is that just reserved for IBCs?
You mean if I have a company called Lickety Split?
Limited, right?
Uh-huh. Lickety Split shareholders is Sam, Joe, and Mary.
Right.
You're asking me if Lickety Split can own shares in Banana Inc.
Right.
Yes.
Okay. How would the list of register or shareholders be then? Is it the name of the company
For
itself?
Banana Inc.
Right.
It would be Lickety Split.
Okay. Okay.
And then if you're doing your due diligence, because Lickety Split is a shareholder of the banana thing, you'd want to know who are the ultimate beneficial owners of Lickety Split, or who are the controlling persons of Lickety Split.
So in terms of subsidiary, Banana Inc. would be considered almost a subsidiary of Lickety Split.
No.
How would that work?
No, only relationship between Lickety Split and Banana Inc. would be that they are an investor, a shareholder.
Okay.
Okay. So if you want an entity to be a subsidiary, we'll have to take Lickety Split. Lickety Split then would incorporate a company, and they would own the majority of shares in that company. So Lickety Split in this organizational structure would be at the top.
Right.
Below it, it will incorporate a company, and the shares of that company below it, say the company below Lickety Split is Vanilla Ice Cream. The shares of Vanilla Ice Cream would be owned 99% by Lickety Split 1% to a nominee shareholder.
Okay,
That's a subsidiary.
okay, thank you.
Mhm. Any more questions? All right, so next class is our last class before the final exam. You see how quickly that time ran up? And we're going to talk about liquidation. And then it's the final exam.
I have a question.
Go ahead.
How are we going to be doing the exam? Is it gonna be on Zoom or is it
In class.
like physically,
Uh-huh.
like show up?
Yes, the mask mandate has been lifted October 1st.
It has, hasn't it? Okay, okay.
Yeah, everybody
Okay.
be walking around without a mask now.
Okay,
coughing.
so this is another important question,
Go ahead.
right? If we were to get a bad score on the exam, is there a do-over?
Mhm.
Okay, okay,
But it'll be a brand new exam.
that's perfectly fine.
For this exam, I will tell you the areas to study. If you do a do-over, there's no telling. You just come and set a new exam. So that means focus on what I tell you.
Got my pen and my paper.
That's next class. Yeah, that's next class. All right.
Okay.
Okay. So you need to be wrapping up your papers. Don't forget now, y'all have some papers for me. One is due on the day of the final, and then y'all have the midterm to hand in. Now, if you decide to use hand in your midterm the same time on the final day, I mean, you can email me the midterm. That means your results may be a little bit longer. It depends. We'll see. All right. But next week, I'll be able to tell you where the 5, 6, or 7 questions, the topics that I'll be focusing on. All right.
Okay.
There's no need to panic. So have a great afternoon. I think we accomplished a lot. We finished that section. So it's just liquidations now. All right.
Right. See y'all.
See you next week, Saturday.
Bye, take care.
Okay, bye. Have a good weekend.
You too.